When there's no more hope is left in me, I can see what comes my way, and I'm always
Welcome to this channel. Hope you all are doing great in your life. Today we will discuss a burning topic, same-sex marriage. The concept of marriage can be traced back in the ancient Hindu scriptures, where the Satarupa and Manu were the first human being to get married under the guidance of Lord Brahma. Satrishi introduced the tradition of marriage. Hereby, the union of a man and a woman was a divine origin. But the first recorded marriage was found in Mesopotamia in 2350 BC. All the ancient civilization and religion has acknowledged marriage and started to take shape of an institution. The primary objective behind the marriage was procreation of children. By institutionalizing it was to clarify the blood lineage. Even in the Hindu mythology, we find the marriage concept, the marriage of Shiva and Shakti. The primary form of marriage was based on monogamy. Some of the important definition of marriage. 1. Oxford Dictionary. The legally or formally recognized union of two people as partners in personal relationship. 2. In Hindu law, marriage is a sacred permanent tie between the man and a woman for social, spiritual and sexual pleasure. 3. In Islamic law, marriage is a contract which takes place after valid offer and acceptance. The purpose is to legalize the sexual intercourse and procreation. 4. In Christian law, marriage is an exclusive, faithful, lifelong union of man and woman. In political sociology, marriage is seen as a socially approved sexual and economic union, more or less permanent. The homosexual marriage is also known as gay marriage or lesbian marriage, where a man ties a knot with another man and woman with another woman. It has not been recognized by the socio-religious community, but the existence prevailing from time. It has not seen as a sacred relationship in religion, but in the modern days, many countries has acknowledged it under law. History of the same-sex marriage. The existence of the same-sex relationship can be traced from the writing in Manusmriti, where the prescriptions of punishment is found in case of the unnatural relationship. So, the presence of the same-sex relationship was present at that point of time, and the same-sex relationship can also be found and traced in the Ramayana and Mahabharata. In the Hindu mythology, more particularly in the Matsya Purana, Lord Vishnu took the form of a charming lady, Mohini, during the taking out of the Amrit, that is the immortal juice from the ocean. Mohini, originally Lord Vishnu, came under the attraction of Lord Shiva, and out of them Lord Ayappan was born, though the Purana does not approve the same-sex love. In Valmiki Ramayana, we find the mention that Lord Hanuman had seen the women in Lanka making love with each other. In the Tamil version of the Mahabharata, Lord Krishna took the form of a woman and married to Aravan. Another interesting story, wife of Guru Brihaspati, Tara, had illegitimate relationship with Chandradev. Out of the love between the Tara and Chandradev, Buddhadev was born. Lord Brihaspati, on knowing this, before the birth of Buddhadev, had cursed him to be a transgender. Transgender Buddhadev fall in love with Ila, another transgender. Out of them, the dynasty of Pandava and Kaurava was formed. In Ramayana, King Bhagirath was born out of the love between the two women. In the stone carving of the Khajuraho, we find the women making erotic love with each other, and man showing their genitals to another. The ancient Indian civilization does not approve the same-sex marriage, though there is mention of its presence and practice. Even in the Vatsayana Kama Sutra, we find the homosexual activities among the men and women. The existence of the homosexuality was prevalent in the various parts of the world, and it was well documented in the history. The ancient history of the Greeks and the Romans put the signature of its existence. In the 1st century, the Roman Emperor Nero married to two men and forced others to acknowledge them as his wives. At least two kings, Nero and Elagabalus of the Roman Empire, found homosexual and married to men. In the ancient Greek and Roman, the culture prevailed of the homosexual marriage, and it was outlawed in 342. Such culture of the homosexual marriage was also found in China, in Guangdong province during the Ming dynasty, where a female marries another female. So, homosexual marriage in form of the gay and lesbian marriage existed. The Greek law never approved the same-sex marriage, but the Roman performed the ceremonies of the same-sex marriage. Later, in the European context, in France, we found the legal contract of embrothement. This contract allowed legally the same-sex union. In Spain, the famous marriage of Pedro Diaz and Muno Vandellas in 1661. Anne Lister was the first woman to enter into the lesbian marriage with Anne Walker in 1834 at Holy Trinity Church in York. America witnessed the presence of the homosexual union. In the 19th century, the word coined as Boston marriage signifies the lesbian marriage. The first recorded same-sex marriage in history was K.H. Numtop and Nyan Kum in 2400 BC. The US had legalized the same-sex marriage in 2015 in the case of Obergefell versus Hodges. Same-sex marriage and law. Same-sex marriage has been legalized by almost 34 countries in the world. Denmark was the first country to recognize the same-sex union without using the term marriage. Instead, they had coined the term union. It is a strong argument which forwarded by the sizable section of the universal society that marriage be the fundamental right. The advocacy suggests that one being is different from another and unique in itself. So, the sexual orientation which led to the love and affection and choice be different from one another. It is the nature which created each of us in its own fashion, and as a being, we cannot disregard it. Even the courts looked that the biological gender is not absolute. When the right to marry of one's own choice and orientation is halted, the question of restriction over the fundamental rights comes forward. The advocates of the same-sex marriage force their argument that by allowing and coining the homosexual union as marriage will not harm this social institution, rather it will forward and improve, while putting their arguments by mentioning that denying the rights is never less than discrimination. While asserting and justifying their arguments, they had taken the reference of the famous remark of the Martin Luther King Jr., the content of their characters. In short, the supporters of the same-sex marriage arguments based on the equal rights is foundational. Generally, the marriage laws are enacted on the basis of the personal laws, and the personal laws are based on the principles of religious faith. In India, we have the Hindu Marriage Act, Muslim Marriage Act, Parsi Marriage Act, and many more. Only the secular marriage is the Special Marriage Act. While dealing with the recognition of the homosexual union as marriage, number of factors require meticulous consideration and interpretation, such as adoption, maintenance, gender terms, inheritance, and many more. Marriage is not about a single right, but a collection of rights on which the jurists and judges are more concerned. In 2018, Navtej Singh Johar versus the Union of India, the Supreme Court has decriminalized the homosexuality under Section 377 of the Indian Penal Code. Same-sex marriage case in India. The backdrop of the recent case Supriya Chakravarti and Abhay Dang versus the Union of India arose after the decriminalization of the homosexuality in 2018. The homosexual persons can live together but not having any legal recognition. The marriage laws does not convey any provision for registration of the homosexual marriage. During the arguments of the case, the learned advocates brought into notice of the Hindu Marriage Act, Muslim Marriage Act, Foreign Marriage Act, Special Marriage Act, but the Honorable Apex Court kept the discussion within the ambit of the Special Marriage Act 1954. The Act speaks about the registration of the marriage on the basis of the gender. On one side, the male, and another side, the female. So the homosexuals are kept outside. The apex court hold that right to marry is not the fundamental right. Court observed in its judgment that the question of insertion or not of the gender neutrality remains in the hand of the parliament. The transgender persons and intersex person right to marry is present in the present marriage laws. The pivotal difference arose in the matter of adoption. Majority disallows the same-sex person from adoption, while discussing subsection 3 of the section 5 of the CARA regulation. Thus, the 5-bench judges of the Supreme Court hold on 3:2 against the legalization of the same-sex marriage and civil union for the non-heterosexual couples. Marriage is always a collection of responsibilities. The particular setup has been construed by the society while institutionalizing the marriage. In the conservative society, marriage is not only the bonding between the two individuals, rather between the families. So, there is a set of expectations always remain with the marriage. The society is changing with the development of thoughts, but the basic criteria remain the same. Marriage dealt beyond the petals of love and affection. There stand the reality of responsibility towards the partner, family, and the society. The question remained with the homosexual couples, while standing in front of the hard reality and strong responsibility, what the heterosexual couples are delivering through the times.